It's wonderful to see you this morning. And just in case you don't know who I am, Janice Bellucci is my name. And I am Executive Director of the Alliance for Constitutional Sex Offense Laws, which is quite a mouthful. So sometimes I just call it ACSOL, just to let you know. With me today is Chance Oberstein, who is president of ACSOL. And we are both attorneys. So if you have any overripe fruit, please keep it to yourself. And many people think they don't like lawyers until you need one, right? So Chance and I are the kind of lawyers, we literally are here to help you, okay? We're not from the government, that might help, all right? So we are here to help you. And today we're going to talk about the tiered registry, a little bit about its background and how it came about, and I'm going to talk probably mostly about that, and Chance is going to talk about the process, and we both have handouts. I'm not going to give my handout out to the end, because if I give it to you now, this is the only thing you're going to read during the entire time. Okay, so, but here it is. This is what it looks like. It's a 4-pager, and what we did is we did our best to break out by offense what tier we think you might be assigned to. Okay, the actual tier you are going to be assigned to won't be known until 2021. So the California Department of Justice gave themselves lots of time to figure out your tier. Okay, and somehow they're going to communicate them to you. Somehow, we don't know what that is yet. Because they say, get this, it is too expensive for them to mail a letter to everybody on the California Registry. There's 100,000 people, right? And I'm thinking even if it costs $1 per letter, surely they have $100,000 in their budget for such an important matter, but we'll see how they plan to do it. Okay, so let's talk a little bit about tiered registries, because 46 out of 50 states in our nation have tiered registries. But California, which started registries, has never had a tiered registry. And trust me, it's been a prime objective of this organization to have a tiered registry in California. Now, why is that? We love everybody on the registry. We support everybody on the registry. But we know that not everybody should be on the registry, if indeed you believe that a registry should exist. But the fact is that 46 out of 50 states have figured out it's safe to have a tiered registry, so you can distinguish between and among people who are on the registry. I mean, we literally have people who relieved themselves on the side of an interstate because it was too far between bathrooms, okay? I get it. I have a very small bladder myself, right? But the fact, too much information, I understand. Okay, but the fact is that you shouldn't end up on somebody's sex offender registry for the rest of your life because you have a prostate problem and you couldn't make it to a bathroom, right? Okay. So, and then we have people who are convicted of heinous violent crimes. And everybody in California has been treated the same way since 1947, just in case you didn't know that already. Okay, so there are 4 states currently that have a lifetime registry for everybody on the registry. And if you look at these other states, Alabama, South Carolina, and even Florida, what do we normally have in common with these states? Thank you. Not much. So why are we in the same club at this point in time? Okay, so this is a very tortured history. And when you see Senate Bill 695/421/384, you know there's got to be an interesting story behind this. And there is, okay? So we, again, tried for 6.5 years to get a tiered registry. And in the very beginning, the effort was by the chairman of the Public Safety Committee in the State Assembly. And he tried to get a tiered registry, and they shot him down. So I was like, well, who are we? In the very beginning of the organization, who are we to think that we can do something that the chairman couldn't do? And by the way, we just joined his bill as supporters in the very beginning, even though we had nothing to do with its creation. But we wanted to cheer him on because he was brave enough to do something like this. So what happened in 2017 was this dream team came together of people, yes, us, ACLU, the California Attorneys for Criminal Justice, and I can go on and on with all these initials, but also the DA's Association, the public defenders, that makes more sense, the victims' rights groups, they were all on the same team with us. And I'm like, that never happens. I remember getting practically thrown out of the DA's Association when I went there many years before, going, hi, we're here to introduce a very rational bill that would, of course, save you a lot of work, too. And they're like, get out of here. What are you talking about? We think all sex offenders are monsters. They always do it again, and there's no cure. So get out of here. We're not going to help you. So just a few years later, that this patchwork quilt came together. And it says 27 others, so we had these organizations backing us up, police chiefs, I can't forget to mention them, and 27 others. These are organizations were backing this tiered registry. Well, when we started out the bill, we had Senator Lara as our sponsor, and our author rather, and he was the perfect author, because let me tell you what, he's gay, he's Hispanic. These are positive things in the state legislature. And number 3, he was a self-identified victim of sexual abuse, Ricardo Lara. And he said, we needed a tiered registry. We're like, yes, yes, yes. Obviously, we're going to be successful this time, right? Until Senator Lara decided he didn't want to be the author anymore. And they can do that to you. And we're like, whoa. You know, it's kind of like you're thrown into a swimming pool, and in the beginning you have your swimming coach with you, and all of a sudden the swimming coach disappears, and you're like, but you forgot to teach me the next thing, right? So anyway, we're upset and confused, and what do we do now? By the way, Senator Lara, what happened in his life is he decided he wanted to run for a statewide political office, and he did, insurance commissioner, and he won. Okay, but he threw us literally under the bus. Everybody, the whole tiered registry bill. So we were sitting there and trying to strain our brains, and Assemblyman Amiano, who was the chairman of the Public Safety Committee, termed out. He wasn't there anymore. And all of a sudden, this brand new senator comes along with an unfortunate name. So I like to refer to him as Senator Scott myself, but his last name is Wiener. Okay, and we even tried to Weiner, but he doesn't pronounce it that way either, so Senator Wiener became the author of our bill. And in the state capitol, I don't know about other states, but you have to go through, for our bills, Public Safety Committee always, Appropriations Committee always, and then you go to the floor of whatever bill, house rather, where the bill started, and then you have to repeat the process in the other house. So what happened in this situation was that and here's more about who the sponsors were and everything. What happened was it got through the Senate. It sailed through the Senate. And we were happy to be there with our pom-poms and cheering on Senator Wiener in these bills, and it got public safety appropriations to the floor. I'm like, well, smooth sailing. This is cool. By the way, we never won an entire house before. It never got to the floor of any house. So we're like, oh, well, whew. No. Then it went to the assembly, and we knew that there was a roadblock there. And I'll tell you her name in a minute. So we went to the Public Safety Committee. People on the Public Safety Committees, they understand our issues. These are people who have wonderful backgrounds. They don't recoil when you use the word sex offender or somebody else uses it, because I try to avoid that and say registrant instead. But the fact is, it got through in the assembly, so two committees, the Public Safety Committee went to appropriations, and I still remember the day. It was a Friday before Labor Day weekend. Okay, Friday before Labor Day weekend. I had testified against a CDCR, some Department of Corrections regulations on one side of town, and I had to run to, actually Ubered it, to the other side of the city so that I could go and be at the Appropriations Committee hearing, only to watch Lorena Gonzalez-Fletcher is her name, kill our bill. And the chair of the Appropriations Committee has that much power. And all they have to do is they keep it in something called the suspense file, and you're dead. Okay, never to be seen from again. And they don't have to give any reason whatsoever. No reason. And so it's like, oh, that was a bad day. It was a Friday before Labor Day weekend. And so I decided I had to go home and drown my sorrows with a glass of Chardonnay, bake some brownies, and binge on Netflix. Anybody ever done that? Yeah, so that's what I did that day. And all weekend I'm holding my head going, I can't believe it, 6.5 years of effort, flushed down the toilet. And but then on Monday, which was Labor Day, like I'm starting to get a couple of interesting emails. And at first I didn't believe those interesting emails, which they said, maybe the tiered registry bill was not dead after all. Okay, so look at the chart here. 421 was a Senator Wiener bill. But that's what Lorena Gonzalez Fletcher stopped. So they had this really strange process in our state capitol called gut and amend. And I was thinking about gutting a fish, but I don't know how you amend a fish. But the fact is that that's what Senator Wiener did. He had another bill that had the number Senate Bill 384, and it had to do with keeping the bars open past 2 o'clock in the morning. It had nothing to do with our topic. But he's like, okay, I'm sacrificing this bill because he didn't get what he wanted anyway. And so he basically stripped out the language and put new language in. Now, why did that happen? Because over Labor Day weekend, the governor, Jerry Brown, who is not known to be a friend of ours, basically called Lorena and said, wrong answer. You will push this bill forward. She will release this bill from the suspense file. And I'm like, okay, so that sounds cool. But then what happened next? Okay, and this is a little bit about the vote. Yeah, oh, here we go. So on September 1, that's when the Appropriations Committee stopped the bill. And then we had this brand new bill, which is Senate Bill 384, but there was a political compromise made. So, folks, I used to be a congressional staffer, and I saw the real stuff that goes on, the sausage making behind the scenes, and it is not a pretty sight. And it wasn't pretty here either. So what happened was that Lorena said, okay, Governor, I will move this bill forward, but you have to give me something. I'm going to change the language of the bill. And if I can move back a couple, oh well. I'll just tell you that, here we go. Senate Bill 421, which is not the bill that passed, would have benefited 90% of the people in the California registry. 90%. And at that point in time, trust me, we heard mightily from the 10% who were going to stay on the registry and screaming and shouting, how dare you. But the fact is, it would have benefited 90%. We lost that. So we're down to 70 to 75% of the people because of the way it was modified. So this second bullet here under the bill modified, anybody who's been convicted of a felony CP offense, and by the way, I'm trying to train myself not to even use the term child pornography anymore, but instead unlawful images. If you think about that term, unlawful images, because unfortunately when a lot of people use the term child pornography, they think of some 5-year-old being raped. Okay, but we have a lot of pictures out there of nude teenagers or scantily clad teenagers, and that's still considered child pornography. Okay, so anyway, we lost everybody who's been convicted of a felony CP offense. They're now on Tier 3. And that makes absolutely no sense for a non-contact, non-violent offense to be on Tier 3, where you have people who've been convicted of several violent crimes. Okay, and also it no longer benefits anybody who's been convicted of 2 or more felony sex offenses unless it came out of the same incident or event. Okay, so the Senate bill got approved by the Assembly, got approved by the Senate. What happened, so the Assembly approved it, it was slightly different than the Senate version, so they had to send it back to the Senate, and the Senate approved it, and lo and behold, Governor Brown signed it. I didn't need any brownies that day, or even a glass of wine. So let's talk about what is included in here. We're talking about a 3-tier system. 10 years, 20 years, and 30 years. So tiers 1, 2, and 3, and tier 3 is on the next chart. So tier 1, it's mostly misdemeanors and things that are considered nonviolent felonies. And trust me, there's a lot of confusion in California because there are a list of of offenses that are considered violent felonies, and a lot of sex offenses are not on that list, which is to some people shocking, other people deplorable, and to some of us, Chance and I, are like, yippee, it's not a violent offense, okay? So if you fit into tier 1, it's going to be a minimum of 10 years. Now, tier 1, look at the word misdemeanor, okay? There are some people out there who've been convicted of something called a wobbler in California, which is a felony that can be reduced to a misdemeanor if you go to the trouble of getting it reduced to a misdemeanor. Talk to Chance Oberstein. He knows how to do that. I do not. I'm a civil attorney. Okay, tier 2, Some violent felonies are here, and the fact is people will be on the registry for a minimum of 20 years. And look at that word minimum these times because that's the way the law is written. Okay, what could change that? It won't, for example, if you were convicted of a failure to register, it won't make you ineligible to petition for removal, but it will extend the period of time before you're eligible. And I believe if it was a misdemeanor failure to register, it's 3 years added on. It was a felony failure to register, it's 5 years. And that can make a big difference in your life. So for those of you who haven't been violated for failure to register, please don't fail to register. And we're not going to talk to you today about what your requirements are in California or any other state, but it's really important that you don't violate. Okay, tier 3 here, and also please pay attention, this is for the adults. People convicted as adults, you might have been a teenager, but if you were tried as an adult, this applies to you. So who's on tier 3 here? Repeat violent felonies and CP offenses, it's still going to be lifetime registration. And I get it. I get that, number one, this is not everything we asked for. Actually, even the first bill, 421, wasn't everything we asked for. And so people have chipped away. But I want to tell you folks, we've had a lifetime registry for everybody since 1947. And the great thing is, it's only 70 years later, the tiered registry was created. However, it does not go into effect until July, not January, July 1st of 2021, the petitioning process. There's different parts of this law. Some parts have already gone into effect. Some parts won't go into effect until 2022. But what most people want to know is when can I petition for removal from the registry? Because there is no automatic removal. Don't think you can sit there resting on your laurels and Good Fairy's going to come and get you off the registry. And that's not going to work. You're going to have to petition for removal, and Chance is going to talk about that. Okay, here's about failure to register and everything. The law says the California Department of Justice has to assign tiers by January 2021. There's other things that they've had to do, set in law, that they haven't done on time. We sued them for those things, like the individual profiles on the Megan's Law website. We had to sue them to put information on there that they were required to put on there by law. And what do you know? As soon as we sued them, they found the resources to update them and complete the things. Okay, so juveniles, just to know, different system. But folks, just because you were 17 at the time doesn't mean you were juvenile at the time. Again, if you were in fact tried as an adult, if you were in adult court, this doesn't apply to you. But basically, it's the same tier, there's 3 tiers just like for the adults, in addition, but the tiers are shorter in duration. So instead of 10 years for tier 1, it's 5. And instead of 20 years for tier 2, it's 10. But there's still a tier 3, which is lifetime. Okay, we're not going to talk, I just want you to know today, we're not going to talk about the changes to the Megan's Law website because that is so complicated that Chance and I would be for another 2 days. So just know that there are going to be some changes to the Megan's Law website. Who's going to be on there, who's not going to be on there. Those changes don't take effect until January 2022. Okay. And I think this is about where Chance takes off. But I want you to know, too, that nothing is set in stone. That's the good news, and that's the bad news, okay? It's not set to take effect until 2021, 2 years from now, okay? If there's another Megan Kanka event, if another blonde-haired, blue-eyed girl gets kidnapped, sexually assaulted, and murdered, we will lose the tiered registry. I'm serious about that. It's like a rubber band being pulled about this thick because there are people who want to undo what we have. And Melissa Melendez tried it this session, earlier this year. She introduced a bill that would have taken everybody who was convicted of 288A, which is lewd and lascivious acts with somebody under 14. Everybody would have been moved up to tier 3. That is at least 40% of the people on the California registry. I do not know why. The DA's offices wanted so many people to plead guilty to 288A, but I will tell you a lot of people pled guilty to that, even people who didn't do it. And they were usually offered a reward. You take this, you'll spend less time in prison, maybe less time on parole. So we have a lot of people, at least 40%. We're talking about 40% 1,000 people that would have been moved up to Tier 3. We stopped Melendez's bill this year, thanks to many people in this room, and you may have another opportunity later, because other people may be taking swipes at it. I will tell you the good news, Lorena Gonzalez-Fletcher is terming out. So, yeah, we don't necessarily need to put up with her too much longer, but we do have a bill going through right now that's not related to the registry, to the tiered registry, which I won't mention, coming through now, and it's made it successfully through the Senate. It's starting in the assembly process, and we're just waiting what she does to it when it gets to appropriations. But I digress. Let's hear from Chance about the process you'll need to follow to, in fact, petition for removal.
Okay, and I do have a few comments before we start about what Janice said, and that is that when you look at these the tiered categories, you see 10 years, 20 years, and lifetime. So California never left the lifetime process, and each one of these tiers, because we have a model for rehabilitation, so to speak, there are rehabilitative periods in California. The current rehabilitative period is 5 years. That's not for sex crimes, that's just in general. Okay, so when you look at these, 10 years or 20 years, they are rehabilitative periods, and they're minimum periods for rehabilitation. The problem is that rehabilitation, the theory itself, doesn't really fit into this idea of tiers, okay? Because it's more about redemption. And the final statement in California is, there are certain folks that can never be redeemed, and that's why they're in Tier 3. Okay, so that's the reality of it. Why? Because punishment extends beyond the conviction and beyond what normally is considered rehabilitation because of the registry itself. So, and I think everybody in this room understands that. And so there's going to be some adjustments to it. There's going to be, and this is a period that we have to either play offense or defense, considering what the issue is. We have to strategize legislatively, and also we might have to litigate after it's all over in order to make the final adjustments. So nobody's out of the mix, and it's just for the moment. And when you hear about incrementalism, what's happened here is incrementally we've moved into a better position to start challenging things and to start shaping things and to redefining exactly what all this is and to understand it better. And so it's a positive move for everybody. It's a positive move. The second thing I'll say is that the process, just like what we were talking about a moment ago, what falls into what category, what is a Tier 1 offense, what is a Tier 2 offense, and what is a lifetime offense, Tier 3. That's not ingrained in stone at all. As a matter of fact, it's for the DOJ to start figuring out. And when Janice and I went to talk to the DOJ after we sued them about how we can resolve this issue, what came up there is, oh yeah, we're short-staffed, in making these profiles accurate so that it reflects on the person rather than in a general category, which can cause a lot of harm to almost everybody, they were 5 years behind their legal mandate. And so the fact of the matter is that if it took them that long, because they're dealing with over 100,000 registrants, how long is it going to take them to determine who falls into the tiers and what? This is a process, and there's no real simple answer here. There's no real simple answer. And when you talk about violent or nonviolent offenses, you have to consider enhancements, and you've got to consider risk levels, and you've got to consider all kinds of other things that maybe staff at the DOJ isn't quite ready to understand or put into the calculus. It's not an easy formula, ever, for anything. So it's this is complex. The same goes for this process. This process is probably the clearest part of the bill. And I'm sure that for the most part, the framework is pretty solid, but it will change too. It will change because changes will be made along the way when glitches happen. But let's just look at it for what it is. Application, petitioners, everybody's got a handout, so you can kind of follow this, but, tier and time. Petitions may be filed upon the expiration of the tier. Again, Janice said, these are minimum times only, and that's exactly what they are. You can make application at the end of the tier, And certainly then expect to have it analyzed by law enforcement, who's going to do a background check to see if you're in fact eligible. And they're looking for things I just mentioned. But first and foremost, how much time has expired? And that's on your handout. Second of all, the DA. The DA could either, one, submit on your eligibility once that's done, or they can oppose it. If they submit on it, the way it's supposed to work is a judge is then supposed to look at it and say, okay, if you submitted on it, obviously, the time's expired and, it's time for this person to drop off the tier. They do not pose a risk to the community. They're not a danger to the community because, after all, registration is as it has been defined by the courts, administrative, and it's monitoring of people who pose a threat to the community. That's what the justification is. Okay, so in that context, a judge is supposed to say, okay, fine, if you're submitting on it, obviously there's not a risk, and you drop off once it's reviewed. If they oppose, and I'm saying if the district attorney's office opposes, they may request a hearing. Okay, and the hearing is based on community safety. And if community safety would be significantly impaired, and that's on your handout, that's what the basis of the hearing is. Now, what factors now within this law can be considered? Well, prior to this law, if you were seeking relief, it's really post-conviction conduct, which means everything that happened after you were convicted. That was the tell of the tape. But in this case, there's a new thing, and it's new, but it's not. In some jurisdictions across California, judges and district attorneys, try to mesh into the analysis the nature of the nature of the offense, and that's tough because that comes before the cart. I mean, this gets you into analysis before you've ever had a chance to work your way out, and it's almost impossible to win that argument because no matter what, you can never change the facts of how this case got there in the first place. So, the nature and consequences of that act are it's a very, very high bar. Okay, and so number one, the new way to look at it now in 2021 is the nature of the registrable offense. That's going to be the first thing. Okay, two, the age and number of victims. And, when we were talking about, why is there a third tier? Well, years ago, Janice and I, again, were speaking to the DA liaison, who drew a big, huge line at age. 14 and under, no way. That's why the issue came up with 288s. Of course, it also has to do with resource allocation. And if you have 40% of the registry in that category, you pretty much defeat the bill. If you say that they all go into Tier 3, it becomes top-heavy again, and you've just defeated the whole process of resource allocation. So, but now we have age and number of victims. That's going to be a tough one, too. Okay, two, whether any victim was a stranger at the time. Stranger danger is going to be considered. Criminal and relevant non-criminal behavior, your conduct. Even if it's a pattern of other things other than sex offenses. Battery, assault, a pattern of traffic violations, I don't know.
Drugs.
But it's, DUIs. But it's another way of saying, you've got to remain a little while because it looks to me like if you're still doing this stuff, you don't have respect for the law, and eventually you're going to act out and do the same thing again. That's you have the time period for which the person is not reoffended. That's an important thing. Successful completion of your 52 weeks of sex treatment, or sex therapy treatment, and, a risk assessment. And that's a whole nother discussion, and I won't get into that right now, but risk assessments will be an important part of the calculus. That is on the DA side. Then, of course, there's factors of mitigation. Now, if you get into a hearing, my suggestion is you don't do it yourself. You get representation, because all these things I just read to you are rebuttable presumptions. Just because they say it so doesn't make it so. It's like this idea of skin in the game. If you don't have skin in the game, but you're looking at sex registration, you can discern within that what's right or wrong. But you got to have skin in the game to feel it, okay? And this is where the rubber meets the road. Just because they say it doesn't mean it's so. And so, you know, you're going to have someone to pick through those to see whether or not any one of these things really is what is being put out there or averaged as a fact in aggravation so that you'll remain on the list. 2, your conduct. I can't even say enough about that. The idea that you take responsibility and the idea that you understand the nature and circumstances of what this was all about and your conformity to just local, state, and federal laws is so important, because if any of that is missing, if there's a lack of it, if there's a record and a pattern, no one's going to let you off the hook. No one's going to stick their neck out, certainly not a judge. And that's the first thing the DA is going to make a huge, huge deal about. Because because those actions reflect directly on your conduct and who you are as an individual versus society. If you're considered a threat to society and you continue to violate its norms and its rules, what do you think the outcome is going to be? It's going to be a negative outcome. And so what you're doing there, is conforming your conduct. And there's more to say about that, but at minimum, you should conform your conduct, and you should act lawfully, and you should live that as a lifestyle day by day. That's the biggest selling point of anybody coming up for relief under the current system or now the new system, because that's the first thing that they're going to look at. Also, when you talk about risk levels, there's ways to really mitigate that, and there, it's kind of like in the post-conviction relief area. When you step up to asking for relief, you want the court to look at you and respect what you've done, and you want them to see that, the opposite of what was once, an evolution of a person who has taken this seriously, understands what the nature and consequences are, and has respect for the process and does what they need to do quickly. So here's the thing. If you're on probation, if you're on parole, don't violate. If you're on parole, don't violate. Do your parole and discharge at the proper time. Maybe you'll get discharged early. A lot of people today are getting 20 years parole. Maybe more, okay, because it's been delegated now, the Department of Corrections, to decide just how long your parole is. A lot of folks come to me and they say, hey, I only had 3 years parole when I got convicted, and now I've got 20. And, and most people buy that, and they say, I'm going to own that, I'm going to do that 20. No, you're not. No, you're not. Because it's almost impossible to do one, and we all know that. There's too many things you got to do, okay? But one thing you have to understand is that it's not 20, because there's also assessments, yearly assessments, and if you do well enough, if you respond well enough, if you conduct well enough, if you express yourself well enough, maybe that 20 reduces down to 10, and maybe that 10 comes down to 5, and maybe 4 and change. If you think I'm kidding, I'm not. Okay, as for people on probation, that's another thing, because you get an opportunity that people on parole don't get. Parole people got to go away. You got to do prison in order to be paroled. But if you get the gift of probation, and I'm saying it's a gift, if you get the gift of probation, you get released into the community. And so it's incumbent upon you to make sure that you finish it as efficiently and as quickly as you can. Why? Because in the state of California, you get an option. When you finish half of that, you are available, at least half, you are available for early termination of probation. And if you get early termination of probation, how can a court later turn around and say you're a high risk, you're behaving improperly? If that's part of your lifestyle and conduct, then that's the first mitigating factor in your case. Does that make sense? Okay. So you get an early termination. Now, some people, depending on how you're sentenced, they have straight felonies, and there's nothing they can do. You can't wobble it down to a misdemeanor, but you can get an early termination. You can, maybe, depending on what the offense is, get a dismissal. What does a dismissal say? A dismissal isn't what you think it is. Oh, it's gone, so I don't have to register anymore. No, that's not what a dismissal is. A dismissal is the acknowledgement by the court that you did everything you were supposed to do on probation, and you did it correctly, and therefore we're rewarding you. We're saying you did it right, and we're rewarding you and saying, therefore, it's dismissed. Everybody looks at that, who knows what it means, says, hey, you know, there were no problems with you. It is an added mitigating factor onto early termination. You get early termination, you get a dismissal, you're looking pretty good right from the get-go, and the spotlight is on you right from that point, including your custody time, by the way. But what I'm saying to you is that at least in the post-conviction section of your journey on this road to redemption, you started out really good. Now, for those of you who are lucky enough to have been convicted of an offense that's a wobbler, what's a wobbler? How can we discern what a wobbler is? Well, look at what your conviction's for and just look at the sentencing. If it says either jail or prison is the punishment for whatever you were convicted for, that means it can be alleged as a misdemeanor or a felony, which means later, under 17B of the Penal Code, it can be reduced to a misdemeanor. If you're lucky enough to have that, then that is the key to how you survive this tiered system, especially if you've been convicted of possessing illegal images. So, here's the deal. The deal is that if you get an early termination of probation, if you get a dismissal, and in that realm, since 2014 for illegal images, you can't. But that's, you know, there are caveats to that. But if you were convicted after 214, can't get a dismissal, but guess what you can still get? And you can get a reduction. And if you get a reduction, you fall to Tier 1. And it's no longer a lifetime offense, theoretically, under the system. So those are the things you can do, along with your conduct, and a few other things. And those other things, well, that's a different discussion, but it will be coming up in a later presentation.
I think we might have time today, actually.
Yeah. but
we have until 12 noon.
Okay, but you know, at this point, I think the handout is pretty self-sufficient in terms of detail, and I think that wraps up my discussion on process.
Okay. Yeah, there might be some questions, but okay. So the tiered registry we fought for it hard, and I want to repeat, we're going to keep fighting. Okay. So people who are even now on Tier 3. When we lobbied Sacramento this year, we asked for an off-ramp so that anybody who was on Tier 3, after 30 years, that they could petition for removal. We didn't get that this year. We're going to keep trying. We are tenacious. And that would allow, again, anybody who's been in the community for 30 years or more and did not reoffend, that they could request of a judge to be removed from the registry. Chance mentioned in passing the certificate of rehabilitation process. We think that this petitioning process is going to be similar to that, but we don't know for sure. And guess what? It hasn't been created, the process, other than, you know, these outlines in the law. But the great thing, the difference between petition for rehabilitation, a certificate of rehabilitation rather, and this petition is a lot more people are going to be eligible. Okay, a huge number of people. And there was a time, I understand, when the dinosaurs still roamed the earth, that it was possible that a lot of people were eligible to apply for a certificate of rehabilitation. But so what's happened over the years is that the legislature kept chopping until it's a very small percentage of people today who are eligible for a certificate of rehabilitation. But let me tell you, if you're eligible, apply for one between now and July 1st of 2021, because there will be no certificates of rehabilitation after July 1 of 2021. They're going to do away with that process. And Chance has been a champion, and I lost count of how many people you have gotten off the registry, but he is the champion in our state for getting people off the registry.
Thank you. Thank you. one thing I will add to what Janice says, and this is a strategy, really, is let's just say, okay, you can get a certificate of rehabilitation if you still have time, even if it doesn't relieve you of the duty to register. And some people may say, well, why would I do something like that? And why, if I can't get relief, what's the point? Here's the point. The point is if you did everything I discussed and you're eligible for it, and a court grants you it in your jurisdiction, that's the same court you got to go to on the tiered system. So, under the current system, let me tell you how impossible it is. You get a certificate of rehabilitation, and under PC 290.5, it says, congratulations, but no relief. It goes to the governor, and the governor has to grant a pardon in order to make that effective. You're never going to get that, because no governor in the whole world's ever going to do that. However, here's the interesting thing. If you get the certificate of rehabilitation, which declares you are rehabilitated, it's a declaration by a court of law, the Superior Court of the State of California. It says you're rehabilitated. How in the world can a court deny you relief under the tiered system when you've already achieved a certificate? It's like gold. So if you're eligible and you can do it before you get to the tier, do it.
Yeah, and I think just a second, sir. So a lot of people don't understand the perspective from the judge. With a certificate of rehabilitation, and I'm guessing it's going to happen with these petitions for removal as well, that a judge is signing on the dotted line that you do not pose a danger to society. Okay, so you might think, well, it's a walk down the park, and okay, I've met all these requirements, and there should be no discretion. There is discretion. Judges have to have a really hard decision to make because state judges are up for re-election. And I'll tell you a story. I don't represent anybody in certificates of rehabilitation. I do the easy ones. If anybody contacts me and it's difficult, I refer them to Chance. Okay? And because I'm a civil lawyer and he's a criminal defense attorney. But I thought this was going to be an easy one. This man had been on the registry for 35 years. He was convicted of a misdemeanor offense. He inappropriately touched a child over the clothes area. Okay? Not the hand down the pants, over the kid's clothes. He took immediate responsibility for it, and he was a teacher. He took immediate responsibility for it. He never taught again. He had to find a new profession and do all these other things. But this is 35 years later. The DA's office in the certificate hearing opposed this man convicted of a misdemeanor offense 35 years ago, never reoffended. He didn't have any offenses of any kind, not just sex offenses. He had no offenses whatsoever, right? 35 years later. And the DA's office wanted to say, well, if he had been in court, now, we wouldn't have agreed to a misdemeanor. And it's like, wow. Too bad. You agreed to it 35 years ago. So even sometimes things that you think are simple are complex because, again, the judge is signing on the dotted line, and it could come back to haunt him or her. And even in that hearing, it was quite interesting to watch because there were 7 cases that afternoon. We were supposed to be the second. She skipped over our number. And I'm like, well, this is interesting. And then I thought about what, and remember my bladder's the size of a lima bean, so I couldn't wait for all the other 6 cases. I had to run to the ladies' room, and my client comes rushing out of the courtroom, and he's like, oh my gosh, what's happening? And I said, let me be the first person to congratulate you. You're going to get your certificate today. And he said, well, how do you know that? I said, because the judge is going to make your case last, and she's going to clear out the courtroom so there are as few witnesses as possible to what the decision she's about to make. And guess what? I was right. He got a certificate that day.
Well, one thing to understand about what she just talked about, which is a part of our conversation here, is that charge that she's talking about is a mini 288A. It's called a 288C, I suppose. And so that's a wobbler, can be filed as a misdemeanor. But that's the small part. The elephant in the room is a teacher and a touching. And that's the elephant. That's what I'm talking about. Rehabilitation? Oh, no. Redemption, yes. And 30 years goes a long way in talking about redemption, plus a whole lot of other factors that I'm sure she brought out to the judge, because no judge otherwise would sign off on that.
Yes.
Yeah.
I think we had a question back there, sir.
Currently, we're starting to work with Chance on doing exactly what we're talking about right now, which includes marshaling the resources to get a secondary residence and a more, it's not Orange County, California county.
Thank you for bringing that up.
Be it Long Beach or it's in LA County, which is the most ideal. I'm a 20-year from incident person. So what have I been doing since then? Got a dismissal. Worked on a portfolio. I found appropriate things to volunteer in, and I have certificates from state assembly people, senators, and congress people. I have certificates of appreciation from a military organization, and many, many, many more things, to include graduating from college. Now, when Chance talks about rehabilitation showing a trend as far as east as from the west, from what you were involved with, building yourself a portfolio, finding something appropriate to participate in, to show the good works that will, you know what they say, when you're a technician, they only remember the one that you didn't fix. They never remember the 5,200 things you did fix. They will remember the one thing that you did not fix. So it behooves you to come up with an avalanche of good to cover up and show that it was an exception, not a trend. Okay. Is it expensive? Yeah, it is. But once again, you know, when you're looking to stand in front of the pulpit and plead your case, you've got to have something to weigh the scales in the other side. And just remember that. There's an old saying, would you do it in front of your mom? You know, if you can't say that you wouldn't do it in front of your mom, then don't do it. Excuse yourself. Have I been invited to things where I deemed was inappropriate for me to be involved in? Yes. I told them that. I said, that's not my thing to do, but I'll help out over here. So, you know, get involved in your own rehabilitation. Build your portfolio. When you hand it to Chance, he's like, wow, well, there's a majority of the work that I don't have to do, since between me and my wife, who is a logistical master, all she's got to do is put me in front of the right thing, say the right stuff at the right time, and then move on to the next thing.
Speaking of moms and dads, my mother said, it ain't the town, it's you. My dad said, look, you got yourself into this thing, you got to get yourself out. And I appreciate the comments, I really do.
Yeah, I wanted to say something about geography, because you did mention geography, and this is a real live example. I had a client who lived in Orange County, and he was eligible for a certificate of rehabilitation. And I said, there's no way. You're not going to get a certificate of rehabilitation in Orange County. And I said, if you move to Long Beach, and he's like, oh, I have this family home and all these relatives. I said, okay, just get yourself an apartment in Long Beach. And he did. And by the way, he found a place near the beach, and he's very happy there on the weekends or whenever he goes. And sure enough, he waited 2 years to make that decision. I took him to LA County and got his certificate of rehabilitation, because it's LA County. And folks, when it comes to these petitions, I think we're going to get similar treatment. So Chance and I are all over the state. Being licensed in California means you can go anywhere in the state of California. I'm rarely in front of the same judge twice, because I go to so many different places, and you get different treatments depending upon where you are. And Chance and I can even steer you toward places. And like the gentleman I just mentioned, he didn't sell his home in Orange County. He kept his home. He has concurrent registration, okay? So he has an apartment in Long Beach. He's got the house in Orange County. He got his driver's license address changed to Long Beach. Okay, there's certain things that Chance and I can help you with and give you information. It's part of it is, you know, what's going to be enough evidence to convince a judge of the right thing. But there are just some places, and Orange County is one of them, jurisdictions to avoid. So I will tell you, the only gentleman that I know has gotten a certificate of rehabilitation from Orange County is Chance Overstein.
Well, but I'm not the only person that's been relieved. I have since then had people relieved through that system. But I agree, it is the toughest jurisdiction of all to do. And you know, the idea is if you can establish a legitimate secondary address, and you know, either jurisdiction will do.
So 2 questions. So the certificate of rehabilitation is where you live, not where you were convicted?
Correct.
Yes.
And why is there a question mark beside file and county where you reside?
Okay, that's because we have people who live outside the state of California
Okay.
who are not eligible for certificates of rehabilitation solely because they live outside the state of California. And I've got some hovering. I feel like it's LAX and the planes are hovering out there. And I don't know if they're going to be able to file or not for removal under a petition, number 1. And if number 2, which county would they actually petition in?
But as it's written, where you live now in
Yes.
California is where you would.
For most people, you're right. It's where you reside, not where you were convicted. Yes, sir.
I've got a follow-up. So how long after completion of probation can you file to have it reduced, and how often is that successful?
Oh, okay. Well, you can file it 30 years after you finish probation. It's a case called Myers. It's a 1966 case. It's really funny you mention that because I went in for a reduction, and it was an old case. And the DA came down. I've known him for about 25 years. And he says, are you sure you can do that? And I said, yeah. He goes, okay. And he sat down. I said, no, come here. Here's the case. You can read it. It's called Meyer, or Myers. Meyer or Myers. So, yes, it can be done at any time. And there are certain factors that go into it. You think, you know, logistically when you're thinking about it, and if you think about it in a rehabilitative context, for every crime except registry crimes, you know, you could check a box, and it's a pretty pro forma, you know, it's pretty easy. In cases that are a little bit more complex and require risk assessment and so forth, it requires a rehabilitative effort similar to doing a certificate of rehabilitation. And that's a whole different ballgame. So it's a thicker thing. It's a more intense process, and it takes a little bit more. But it just really depends on what the conviction's for, and it really depends on how you did your probation and other variables. So yeah, seek guidance before you decide to do that.
Oh, William.
Regarding being removed from the tier registry, and showing that we are no longer a threat. I went to the board as a lifer for 3.5 hours. I sat in a hearing, and my commissioner was Arthur Anderson, who is the chairman of the board of commissioners. We spent a majority of the time in my hearing on my past offense, which is now 32 years old, which was a 290 related offense, and very little time on my current offense, which has nothing to do with 290 related. At the end of the hearing, he found me no longer a current risk to society, and found me suitable. And that was signed off by Governor Brown. Does that carry any weight in being found in the court's eyes?
Well, it does. It absolutely does. And having done lifer hearings myself, I understand what you're talking about. It used to be that you could bring up facts and circumstances and wipe out everything else that you've done. Everything else that you've done, just based on that. And then you've got the victim's impact statement that almost always happens, and you know, the board goes south. But if you've got something like that, to me, that's gold. So it very much counts because it's mitigating.
Yeah, I would like to piggyback on what he just said, because that just happened with me. After 27 years, I was found suitable by the Board of Parole hearings, and one of the factors that they looked upon was that I met the criteria as a youth offender at the age of 25 when I committed my sex offense crime at the age of 22. So my sex offense crime was 29 years ago, but my life crime began when I was 25. And they said, well, you know what? We see that because of this, the guidelines under AB 1308, youth offender law, you fit the criteria as a juvenile under the basis that your brain is not fully developed until you reach the age of 25. So what I'm curious is there any movement currently by ACSOL or by ACSOL or anything like that that is incorporating the youth offender movement that's incorporated by the Department of Corrections under the state legislative laws of SB 260, 261, and AB 1308 in order to meet criteria that would allow for less registration requirements.
That is the legislative department?
Yeah.
There.
And the very quick answer is no, but that's because there's another organization that's doing it. So I'm trying to remember what the name of her organization is, but it's Nicole Pittman. So Nicole is out there, and she's quite the zealous advocate for people who were juveniles. And so we leave juvenile issues to Nicole. Yes, sir.
This is a question for Janet. Did I understand you correctly to say earlier that we should do this before the tier goes into effect?
Yes, you did hear me correctly. If you're eligible for a certificate of rehabilitation, even if you don't qualify for relief under the limiting statute, which is 290.5, yes, you should. Yes, you should. It's a good test run. It will get you organized. It will show you, it will give you a good indication on how you're going to fare later. And if you're successful, you've got to go to the same court to get relieved under the tiered system anyway, and it's going to be before the same judge. And how can the DA come in and speak with a forked tongue? How can they even oppose you? So it's a really good idea.
Yeah. Folks, there's other things you can do too outside of the legal process. And here's an example with one of my clients. He and his wife did the Share a Highway program, and Adopt a Highway. And they were out there picking up trash every week, all right? And the judge really liked that. I mean, he'd done other things too, but Adopt a Highway, and you were there, and you did it on a regular basis, and I think it does cost some money as well. But those are the types of things, clean up a beach, you know, just make sure the things that you do don't involve children. Even if your offense did not involve a minor, because you could get outed as a, quote, sex offender, and that will not go well. Yes, sir.
To do it before you can is that the certificate of rehabilitation proceedings take time.
Yes.
Comes July 1st, 2022, we have 100,000 people, out of which 30% are going to be applying. The courts is going to be crowded, and I don't know if they have enough manpower to accelerate it.
I'm glad you brought that up, because when people ask me, I say get prepared on July 1st of 2021 to submit your petition, right then and there. Because the people who submit early are going to get heard, not just first, but way first, because there's a tsunami coming at them. And by the way, they know this, and the judges supposedly are doing something about it. The Judicial Council, they're talking about it. They're even out there talking to the DA's office, the District Attorney's office. Supposedly they're going to get around to Defense Counsel sometime, but they haven't bothered to talk to us yet. So, but you're absolutely right, and it's going to be a lot of people at the same time. And if you all are prepared, and I love your, he left. Okay, so him, that he's already preparing his portfolio. Prepare your portfolio now. Maybe it's like going for a job interview, right? Have your ducks in a row. Get your attorney. Oh, but let me say this. Be really wary and suspicious of letters that you get in the mail, okay? I have seen some letters that cause me great concern, and one of them to the point that I picked up the phone and I called the lawyer, and I basically said, how dare you? You are misrepresenting what the law says. Oh, by the way, you're also claiming that you've already successfully represented people and petitioning for removal. How could you do that? It hasn't even gone into effect yet. Right? And so he thinks that he's covered his posterior through fine print or whatever, but I don't think so. Okay? So be very careful of letters like that. If you want to stomp on them, feed them to a shredder, whatever, if you want Chance or I to look at them and see, does this seem like it's a valid offer? Okay, or this person knows what he or she may be talking about. But unfortunately, guess what? There's quite a mailing list out there, right? And our organization uses it too from time to time. Whenever we go to one of our monthly meetings to a brand new location, we send 500 letters out to people who live nearby, that have zip codes nearby. Okay, to let you know, even though it's really expensive. And I don't know how these attorneys can do it, because it is so expensive. But oh well, I guess you send out 500 letters, that's $500. And if you get even one case, maybe it's worth it. But be very careful when you get these solicitation letters. Sir, I think you were next.
Yeah, Chance, through you, Chance, you mentioned dismissal. Are you talking about expungement of a case.
It's the same thing. It's 1203.4. Dismissal, expungement, same thing.
Yeah, I got that for mine, and I did it just because I wanted to have that in my portfolio. But people need to know that doesn't mean that, you gotta expunge, that's all great. That doesn't mean that you're gonna get off.
Well, let me say this about that, and I mentioned that before. It's not getting off the register. It's not about that. But let me say this also. Anybody who's gone to prison and they want to apply for relief under the current system doesn't need a dismissal. They can just go straight to the hearing, okay? But if you're granted probation, then you have to complete probation successfully in order to qualify for relief. So your expungement is the first prerequisite. So you need that.
Yes?
I have a question. If you apply for the certificate of rehabilitation and somehow, some way, it's denied, right? Now, July of 2021, is that going to even look worse for you?
I don't think so.
Oh, okay.
I don't think so, because if it's denied for a reason. Take a look at the transcript and underline why it was denied, because that's what you need to fix it.
What if it happened 30-some odd years ago when you can fix it?
Well, it depends, and I would say seek guidance through an attorney,
Okay.
have someone analyze it, and tell you what you need to do.
Okay.
So another story, the same gentleman that had been on the registry for 35 years for a misdemeanor, he had applied 5 years before that for a certificate, and he was unsuccessful. The reason he was unsuccessful is he didn't get any letters of support. He had nobody vouching for him. Now, why didn't he have any letters of support? Because nobody knew he was on the registry. He didn't tell his friends. He didn't tell his family. He was a gay man married to another gay man who was from a large Hispanic family.
Gotcha.
This is how they found out he was on the registry. He sold his car to a niece or nephew. The niece or nephew drives it to the county fair and gets stopped based on license plate and says, "You can't come in." "Why can't I come in?" "You're on the sex offender registry." "No, I'm not." That's how she or he found out that his uncle was on the registry. So, and it was a bad day. You can imagine the whole family finds out all at once. But the fact is that it was also a great blessing because they said, "We know who you are. We love you. You want a letter? We'll give you a letter." And once he had those letters and my support, my legal services, he was successful. So that's an example of somebody who was denied and then went back.
So he was actually able to reapply then?
Yes, absolutely, same court.
Let's put it this way. Usually they're denied without prejudice. Okay, so that's why you can reapply.
Right, okay.
And this really interesting thing she said, because it's a good point, and for everybody. If you live under a rock and you're not transparent, and you're not even sincere, okay? Because sincerely, if you're transparent, people around you know who you are and what you're about, and they are your best testimony of your growth over a period of time, your maturation from one point to the other, okay? And in establishing all this, you need that. You actually need that. So when she says he had problems, he had great problems. She's not the only one that's had clients walk in and say, "Oh yeah, I'm great." They are. They haven't reoffended. They're the right age.
Right.
They're great. But there's no one there out there to say so. So, good lesson.
Another thing that I want to bring up to folks is we have a lot of people on the registry who are addicted to a substance, alcohol or drugs, to sex, right? And many of you are going through 12-step programs. That is great for your portfolio if you've actually completed it. Like, I'm 17 years sober, all right, or whatever it is. The fact if somebody else can, and certainly an objective person, can testify to your overcoming your addiction, that does help a lot. So think about that too. Again, if you've gone through an addiction program. By the way, if you've been sober for 27 hours and not 27 years, don't put that in there. Oh, wait, you already asked one question. Yes, sir.
Sitting here, whether the victim was drinking, does the court take into consideration whether it was a family member?
Well, that's on there because that's one of the factors the DA is going to use in opposing, if they do oppose, and the court's going to have to deal with that. But those are DA factors. Those are factors that aggravate the case so that you may be continually, so the monitoring will continue. That's the opposition. he should stay on or she should stay on the registry because, and those are the factors they're going to use.
And think about it, folks, one of the things that everybody's so afraid of is stranger danger. So that's why, indeed, that's a factor. Okay, there was, yes, ma'am.
Yes, I just piggyback on what you just said. So let's say if you're convicted of looking at improper images.
Yes.
So does the court has the tendency to see those people on images as the victims or?
Yes, the people on the images are victims, and they'll be strangers, right? Unless, I guess, it's a family member. Yeah.
So that will count more, you think, in your experience? Does it count more?
Oh,
Does it count
well,
less?
let me say this, it's, the nature and circumstances are going to be relevant in terms of the analysis of the tier. Not so relevant now under current relief. So if you can get a certificate of rehabilitation before that time, wonderful.
Yeah, and I think it might depend on the images, quite frankly. Because think about it, folks, if you're looking at a picture of a nude or scantily clad teenager, just being natural, as compared to a violent act and a fight with a 5-year-old, I think that would make a difference to a judge. Yeah. I think there was a question way in the back. That's all.
Are all offenses eligible for certificate of rehabilitation, or are there certain categories?
Very few.
Quick answer, no. Seek legal advice.
Yeah, yeah, very few are now eligible for certificates of rehabilitation. That's why a tiered registry is an amazing and wonderful thing. There are so many people, and even as this pullback because of Lorena Gonzalez-Fletcher, but still 70 to 75% of the people on the registry will be eligible to petition for removal at some point in time. Again, 10 years, 20 years, yeah. And the 288As, again, I can't overemphasize the importance of keeping 288As off of Tier 3. And it was really interesting. I went to a sex offender management board meeting, and one of their board members said, and I never knew this before, she said when they fought for the tiered registry, they said 288As have to be in Tier 2 or we're out of here. And we're gonna create our own bill. Because they understood so many people were convicted, pled guilty to 288A. Okay, lewd or lascivious acts under 14. That's what 288A is. And I, honest to God, don't know if they passed out merit badges or Starbucks cards or a check to people, to prosecutors for getting another 288A conviction. Because many people I've talked to said, I didn't do that. I did this other thing. But hey, they had dangled this carrot in front of my nose, and so I pled guilty to that offense.
Well, and the truth of the matter is, under the current system, you get a 288A and it's lifetime registration. No questions asked. That's it. You're done. This opportunity here addresses the top-heavy portion of relief in California, and so if you just put back 40% back into the mix,
Wow.
you've got the same umbrella, okay, and it's top-heavy, and so the reason law enforcement supported this tiered system is simply resource allocation. They said, we don't have to monitor everybody. Maybe we should only monitor people who actually pose a risk. And that's what this whole thing's about.
Shocking. There's somebody over here that had their hand up. Yes, sir.
Okay, so this is in regard to tiered registries. I like the gentleman in the far corner that had 20+ years.
Okay.
Orange County, unfortunately, the DA who inherited my case was having none of it with me because the DA who was on my case got arrested today, my first hearing. Anyways.
Wow.
So this is way back when, you might know Marshall Schulman from way back in the day. Anyways, so I understood that if I moved out of Orange County right away, so I understand that if I apply for the tiered registry, the DA gets informed in my jurisdiction, but I also understood that the DA from the original conviction also gets informed. And I'm like worried that that's the one that has the axe to grind.
Okay, so under certificate of rehabilitation process, that is what happens. So you apply to the county where you currently reside, and yes, where you were convicted, that county gets notified. I don't even know even one time that the county where you're convicted cared, including the man who moved to Long Beach. He'd only been in Long Beach for 6 months at the time he went forward. That was the thing I was the most nervous about. They're like, oh, that's not long enough, but I wouldn't worry about that. Chance made a comment in passing that I think we should talk about briefly, and that has to do with what's going to happen after the tiered registry goes into effect. Let's just say nothing changes between now and the next 2 years. Well, some of us are getting ready to file lawsuits. And the reason is, it's called equal protection. Okay, so there's a clause in the U.S. Constitution, and in fact, Adele mentioned that in one of her cases. That was one of their claims, was equal protection, lack thereof, actually. And so if you think about it, you got somebody who's convicted of a non-contact, non-violent offense, like possession of unlawful images. You got somebody here who's raped 10 kids, and they're both on Tier 3. Sounds like a lack of equal protection to me. So we're watching, and as much as we would like the law to change, and we can move our CP offenders down to tiers 1 and 2, and by the way, we have some great arguments. This is the biggest one. The federal guidelines say that possession of CP should be tier 1. That's a recommendation, tier 1, not tier 3, tier 1. And that production and distribution, tier 2. Okay, so we went into the state legislature this year in February and said, why don't you follow the federal guidelines? I don't like the federal guidelines. I'm usually fighting against the federal guidelines, but man, if they're going to help our cause, then we're going to use them. Okay, so equal protection litigation is on the horizon. We will be prepared when that happens. So think about it. Again, we'd like the legislation to change, and sometimes when you file a lawsuit, voila, all of a sudden legislation appears to solve the problem. Yes, sir.
I'm just curious, when does the time start? Because I'm still on probation for just slightly less than 2 years. Does that 10, 20 years start after my probation ends?
No.
Or is it after I got out of jail?
It's upon release from custody, okay, which is a beautiful thing. At least that's the way it says it right now, right? So if some of these 20-year parole periods and everything, they don't count. You don't have to wait until then to start counting. Maybe I should put it that way. It's when you're released from custody, whether it's jail or prison, okay? And even if you only spent one night in jail, that counts.
Now, there's going to be some people who never get arrested because they're going to turn themselves in, they're going to get processed, or that arrest was never a possibility, got something in the mail for the something minor, but minor in terms of prosecution, maybe a misdemeanor offense that required registration. That's what I mean by machinations. There's going to be adjustments. So, if in sequence of time, not everybody's done custody, so there's going to have to be an adjustment, I suppose.
There's some hanging chat out there, and some of us lawyers were expecting the Department of Justice, the California Department of Justice, to issue regulations implementing the tiered registry law. That's what agencies do, right? And they said, nope, we're not doing it. What? How can you not do it? We're gonna distribute answers to frequently asked questions. Folks, that does not have the weight of law, answer to a frequently asked question. And so I'm concerned about how things might become unequal. And I'm not going to say it because it's being taped. Yes, sir.
Obviously, any of us are going to be happy if we get off the registry at all. So this is kind of a lighter question, but assuming everything goes golden, we go through the entire process and the judge goes, yeah, take them off the registry. Is there a time limit or some sort of time they're given with which to actually remove someone from the registry?
It should happen relatively quickly. So I know in my certificate cases, if my client gets off the registry, by the way, I have a 100% success rate. The fact is that I get the court document and I immediately send it to the California Department of Justice and say, take them off. And they do. Okay, don't wait for the courts to do it, as Chance knows well. God only knows what they're going to do with the paperwork. They're slow, they don't, whatever reason. The fact is, DOJ knows that day. Yes, sir.
Actually, off of that, once that happens, and let's say you do get off, do the travel restrictions and things like that change? Do the passport, can you get a regular passport without any little signifier?
Well, the answer is yes, but go to the domestic and international travel talk today and learn more about it. But the answer is yes, with caveats.
Okay, so I'm going to expand upon that answer because we have a little bit of time. And so I had a recent client who I've never met, by the way, because he's in Asia. He got into Asia somehow. Okay, great for him. He was traveling on business in Asia, and not him, but his mother got a letter from the U.S. State Department telling them that his passport had been revoked. Now, he's on business travel in a different country where he lives, and his U.S. passport has just been revoked. And thank God his mother told him, right? Because the next time he tried to go to another country, they go, no, you don't have a passport. And they said, you have to have that unique identifier added to your passport, right? And through the course of events, what I found out was that he had left the state of Virginia 3 years prior, had not returned to the state of Virginia, thank God, wasn't required to register in any state in the United States of America, okay? And I found a Virginia state lawyer who was willing to sign a piece of paper that said he was not required to register. In fact, I think they were pretty pissed off that the federal government was interpreting Virginia state law and was willing to sign that letter. And I gave that letter to the Department of Justice, State, and they reversed themselves. And so he was able to go to the consulate and get a passport without the unique identifier. But I want to tell you, it took 6 weeks.
Wow.
And that was fast. All right, but it would also involved a holiday, and as attorneys, we send this information to an email address, not a person. We don't even know who it is. There's no phone number. We don't know if they ever get it until they feel like answering it. So I think you've had your hand up several times. Oh no, you just answered your question. Yes, ma'am.
What's the relationship between the registry and Megan's List? Does the same body control the registry as will control Megan's List? You can tell from my accent, I'm a little bit ignorant about this.
Okay, so the California Department of Justice in our state controls both, okay? They control both. And here's a fact that many people don't know. They actually update the ACSOL website every single day. Every single day. That's why if I get a certificate of rehabilitation, I get it right in. By the next day, that person's taken off, okay? Because it actually happens in the middle of the night. Now, some of the people that they hire are not so good. Like this one time, I had this man, and he was at the end of parole. And at the very end of parole, he was so nervous. He's like, oh, I know my parole officer is going to violate me for something that I didn't even do. And I was like, be calm, he's going to be fine. He's in Orange County, by the way. And I said, just keep following the rules. And one day, I happened to look at his profile on the ACSOL website, and I go, dude, I call him up. I said, you've been violated. And he's like, what? But it was said that he was in violation for failure to register. And that was total nonsense. So got a copy of his signed documents and everything like that, got him to DOJ. Again, they changed it. The next day I look at it, and it says he's incarcerated. I'm like, oh. And some low-level administrative clerk was kind of busy that night, didn't have enough caffeine or whatever it was, and put in the wrong code. So, and I called him that time, and he picked up. I went, oh my God, they let you have cell phones in jail. And he's like, what? And I said, well, it says you're incarcerated. So I took another email to an attorney in the agency, and they did fix it. But that's the kind of stuff that happens.
But following the question, can I continue?
Yeah.
If you get your certificate of rehabilitation and you're off the registry,
Then you get off of
you
Megan's.
have to also then take action yourself to get off Megan's law, or is it going to happen with that?
No, the answer is no. The answer is it cleans up all that.
Sorry?
It cleans up all that.
Well, but specifically, your attorney should send that information to DOJ immediately by email, okay? I scan the court document, I send it to DOJ and say, take him off. He's now a free man, okay? But otherwise, yeah, the court will eventually get around to sending that document to the California DOJ. It's a large agency. I'm sure they have a very busy mailroom, and God only knows, it could take up to 30 days.
It could, but it's required by state law. They have to transmit it. Read the law. That's what they have to do. But the ultimate effect is yes. The answer is yes.
Lots of hands up. Yes, ma'am.
You were talking about equal protection legislation
Yeah.
lawsuit. You went from looking at media
Yeah.
to 10 rates.
Yeah.
So that's a little bit, someone's in the middle. Are you gonna?
Well, folks, okay, we always look for the Rosa Parks case to be our first case, right? Because if we can argue that this big difference, then what we do in the later cases is we go, well, it's more like this than that, okay? So in other words, it's more than looking at a photo, but it's less than 10 rapes. And, it's really, judges have some discretion. Usually that's a good thing unless you're in Orange County. Okay, sorry. William.
On the registry, when you start with 10, the time for the
Yes, absolutely. So
Correct.
if you go, let's just say that you go, if you were convicted of a sex offense, that's a good question, you go to jail or prison, you get out, the clock starts ticking, then you go to jail or prison for another offense, let's say a DUI, but it stops. It's called tolling, Tolling. And so they don't count any of that time while you're in prison, but once you get out, they start counting again.
Even a violation or,
You mean an infraction?
even if it's a parole violation or probation violation, not necessarily.
Yeah, they toll. If you spend any more time in custody, it's tolled.
Well, let's put it this way. If you get a probation violation, unlikely you're going to get a dismissal, unlikely you're going to qualify for a certificate. You're out. If you get a parole violation, there's still hope, believe it or not. It's just the anomaly of the way things are done in this state.
Yeah, and again, judges have some discretion how to interpret it. Yes, sir.
Just to clarify, if you are arrested and convicted, then it's told. If you are arrested and then exonerated, the clock is not told.
Maybe. No, I'm serious, maybe. It depends on what the facts and circumstances are surrounding all that. And it depends, it's, highly dependent on the discretion of the court. In terms of rehabilitation, the court has a lot of discretion there. A lot. So, and unless they abuse that discretion, things stay as the court says they are. So, yeah, maybe. The answer is maybe. Maybe.